Welcome to Crisis and Perception, where we examine the systems shaping our world. I am so glad you could join us today because we are tackling a premise that has the potential to completely rewire how you look at the global economy, at history, and honestly, at the news you read every single morning.
It really is one of those topics that changes your entire lens on reality.
It absolutely is. So I want to ask you a question. Markets are often described as the engines of wealth creation. We are taught that if you have a good idea, you work hard and you bring it to the market, wealth is the natural outcome. But what if the most powerful mechanism behind wealth is not markets at all, but law?
And that is a profound shift in perspective. The belief that wealth accumulation is a purely natural economic process driven by the invisible hand of the market is, well, it's perhaps one of the most pervasive myths of our time.
Right, it treats wealth generation as this organic, almost biological outcome of human trade.
Exactly. But when you start to look closer at the foundation of that trade, the natural market explanation starts to fall apart. And that is exactly what we are going to deconstruct today.
So the source material for this deep dive is a truly groundbreaking book by legal scholar Katharina Pistor. It's called The Code of Capital: How the Law Creates Wealth and Inequality.
It's an incredibly detailed systems-level analysis.
I have to say, reading this book felt like someone handed me a pair of X-ray glasses for the global economy. Our mission today is to systematically decode how ordinary, everyday assets, things like a piece of dirt, a promise between two people, an idea, or even a string of digital code, are transformed into what we call capital.
And the way the transformation happens is by embedding those assets within very specific legal structures.
Which brings us to the core issue. What is the actual crisis in perception we are confronting here?
The crisis lies in the widespread belief that capital is created primarily through markets. We widely believe that capital is just an economic reality. You have money, you invest it, it grows.
Right.
But Pistor's analysis reveals that capital is not simply money or property. It is legally engineered privilege. It is a status granted to an asset that is backed by the coercive power of the state.
So once you start to see this invisible legal architecture, the entire system of global inequality looks completely different.
It stops looking like a natural occurrence of a free market and starts looking like a highly engineered construct designed by specific actors for specific outcomes.
Okay, let's unpack this. I really want to ground this for you before we get into the heavy legal mechanics. We need to visualize the sheer scale of the inequality this system produces.
Yeah, the data is pretty stark.
In the research for this deep dive, I came across this fascinating and frankly alarming chart that economists refer to as the elephant curve. I had actually never heard of this before. Can you explain what this curve is and why it's so important to understanding the urgency of Pistor's work?
Yeah, so the elephant curve basically maps the growth rate and the amount of wealth captured by different global income groups between roughly 1980 and 2017.
Okay.
If you look at it on a graph, the line literally forms the shape of an elephant's head and trunk.
Hence the name.
Right. The broad forehead of the elephant represents the bottom 50% of the world's population. Over that 37-year period, that massive group of humanity, literally billions of people, captured only 12% of the growth in global wealth.
So half the planet only gets 12% of the pie.
Correct. Then the curve dips down into a valley, the elephant's face. This trough represents the squeezed middle classes of advanced Western market economies. Their income growth over those 4 decades was nearly stagnant.
That's the hollowed-out middle class we always hear about.
Exactly. But then the curve shoots steeply up to form the raised tip of the elephant's trunk.
And let me guess, that trunk is the ultra-wealthy.
It is the top 1%. That 1% captured 27% of all new wealth created during that period.
Wow!
That is more than double the amount held by the entire bottom half of the global population. We are looking at levels of inequality that echo the ancient regime before the French Revolution.
Okay, so this brings up a massive question. When I look at an inequality gap that huge and that resilient, because it survives market crashes, it survives wars, political upheavals, I have to ask why. Why is it so structurally sound?
That is the right question to ask.
Because when I took Econ 101, I was taught about K versus L, capital versus labor. Capital was always presented to me as just physical stuff.
A factory, a tractor.
Right, a fleet of delivery trucks. You use the stuff to make goods, you pay the labor, you take the profit. Or if you look at the Marxist critique, capital is primarily a social relation where the owners of the stuff exploit the labor.
Both are very traditional views.
But Pistor is saying both of these traditional views are fundamentally missing something, right?
Yes. She argues that both classical economics and traditional Marxist views miss the underlying machinery. If you reduce capital to just physical objects K versus L, you can't explain why a piece of paper representing a complex financial derivative can generate billions of dollars without producing a single physical good.
Right, because the derivative isn't a factory. It's just math and contracts.
Exactly. Capital is not merely a physical object, nor is it just a social relationship. Pistor defines capital as being made of two distinct ingredients, an asset and a legal code.
An asset and a legal code. Let's break that down.
Think of it this way. In their raw, unadulterated form, assets are just things. A plot of land is just dirt and rocks. A promise to pay someone $50 in the future is just air vibrating in a room.
Or a chemical formula is just an idea in a researcher's head.
Precisely. But with the right legal coding, any of these simple assets can be turned into capital. The law fundamentally alters the asset's propensity to create and protect wealth for its holder.
This actually makes me think of Thomas Piketty. A few years ago, it felt like everyone was talking about his book, Capital in the 21st Century.
Yeah.
He had this famous equation, R is greater than G.
The return on capital historically outpaces the rate of overall economic growth.
Exactly. So if the economy grows at 2%, the return on capital might be 5%. And over decades, that compounding interest turns into dynastic wealth. But Piketty mostly just observed that this happens. He documented the data. He didn't necessarily pop the hood on the car to show us how the engine produces that specific result.
And that is the perfect bridge to Pistor's work. She solves Piketty's puzzle.
How so?
Well, why does R consistently beat G? Because, as Pistor shows, capital is placed on legal steroids. The legal coding protects the asset holder from the headwinds of ordinary business cycles. It gives their wealth an unnatural longevity.
While an ordinary worker's wages or a local restaurant's profits are fully exposed to the brutal realities of free market.
Right. Sudden downturns, fierce competition, inflation, ordinary assets are exposed to all of that. Capital is legally shielded.
Wait, I want to push back on that for a second. If I listen to financial news or read op-eds by prominent investors, the reigning narrative is that government regulation and state intervention are the enemies of wealth. They always invoke Adam Smith.
The invisible hand.
Right. The invisible hand of the free market is supposed to be what creates wealth, not the law, and certainly not the state. How does Pistor reconcile her theory with the foundational idea of free market capitalism?
It is a brilliant question, and it reveals one of the greatest historical amnesias in modern economics. When Adam Smith wrote about the invisible hand and the wealth of nations back in 1776, there was a massive caveat in his writing that almost everyone conveniently ignores today.
What was the caveat?
Smith explicitly stated that every individual endeavors to employ their capital as near to home as possible.
Why? Why would they have to keep it local?
Smith wrote that the investor prefers the home trade because they can know better the character of the people they trust, and crucially, they know better the laws of the country from which they must seek redress. The invisible hand was fundamentally designed to work when legal structures and capital were geographically local.
You knew the local magistrate, you knew the local debtor.
You understood the local court system.
But today, capital's completely footloose. If I buy an index fund, my money is crossing oceans in a microsecond.
Exactly. The localized invisible hand is obsolete. Pistor argues that the global legal code has entirely replaced the invisible hand. Today's asset holders don't need to stay home to seek redress or feel secure.
They can just shop around for the best laws.
Yes, they can pick and choose the legal systems they prefer from a global menu. They often opt into foreign laws that offer the best tax rates or regulatory relief without ever having to physically move themselves or their businesses. The legal infrastructure allows gains to be made and pocketed anywhere, while the losses are often stranded wherever they fall.
So bringing this back to you, the listener, think about the narratives we consume. When you read a glossy magazine profile of a billionaire, the story is almost always framed around their singular genius, their grueling work ethic, or their unique disruptive vision.
And sure, those traits might be present. They might have worked very hard.
But what this deep dive will show you is that hard work alone doesn't create a billionaire. Their ultimate superpower, the real structural advantage, is their access to the legal code. Without it, their fortunes would be incredibly fragile and short-lived.
To understand how this superpower actually functions, we have to look at the anatomy of capital. How exactly does a lawyer take that raw dirt or that simple promise and turn it into protected wealth?
Right. What are the actual mechanics?
Pistor identifies 4 structural attributes. You can think of them as 4 distinct legal superpowers that the law grants to an asset to elevate it to capital. The first attribute is priority.
Let's really dig into priority. This is essentially about who gets to cut the line in a disaster, right?
That is an excellent way to conceptualize it. Priority ranks competing claims to the exact same asset.
Walk us through a scenario.
Let's imagine a local manufacturing business goes bankrupt. It's a total failure. When that happens, everybody descends on the debtor at once. The employees want their final paychecks. The local suppliers want payment for the raw materials they delivered last month.
The municipal tax authority wants its due.
And a massive global bank wants to recover the massive loan it extended to the business.
It's a scramble for a shrinking pie. There just isn't enough money to pay everyone.
Precisely. And this is where priority steps in. Priority determines the legal hierarchy of who gets paid first. If your asset has legal priority, for instance, if the massive bank is a secured creditor holding a lien on the factory equipment, that bank gets to pull those secured assets out of the communal pool entirely.
They just take the equipment, sell it, and recover their losses.
Yes. The unsecured creditors, the employees, and the local suppliers are stuck at the back of the line. They have to settle for pennies on the dollar if they get anything at all from whatever scraps are left over. Priority is legally sanctioned line jumping.
Okay, so priority is your ace in the hole when things go wrong. But let's say I have priority. I survive the bankruptcy of one company. That alone doesn't build the kind of dynastic wealth that Piketty talks about. I need my wealth to survive long after I'm dead.
And that requires the second attribute, durability.
Durability.
Durability extends wealth structures across time. It is the attribute that shields assets from too many competing creditors over generations. Look at history. It is full of tragic figures who built empires, made one bad bet, and lost everything, their land, their homes, their businesses, to their creditors.
Or think of the classic trope of the wealthy founder who builds a fortune only for their prodigal children to gamble it all away and lose the family estate to debt collectors.
The shirt sleeves to short sleeves in 3 generations proverbs.
Exactly.
If you want to turn an asset into lasting capital, you need a legal mechanism that insulates it from the human frailties of its owners. You need to ensure that even if a business venture completely fails, or if an heir racks up massive personal debt, the core capital remains legally untouchable.
Durability builds an invisible fortress around the wealth so it can compound undisturbed for decades or centuries.
That's right. And then there's the third attribute, which is where the X-ray glasses really start to reveal the bones of the system. The third attribute is universality.
Universality. I feel like this is where the state really enters the picture.
It is perhaps the most crucial link to state power. In the legal world, it is often referred to by the Latin term erga omnes, meaning towards all, or against the world.
What makes that a superpower?
Think about a standard contract. If you and I sign a contract where I agree to sell you my car, that contract only binds the two of us. If a random stranger walks up and tries to take the car, our contract means nothing to them.
Because they never agreed to it. They didn't sign anything.
Right. But universality means that your priority and your durability rights are respected by absolutely everyone globally, even strangers who never agree to your contract and have no idea who you are.
And here's the critical point. The only way to achieve universality is if a powerful third party stands behind your claim and forces others to yield.
And who is that third party? The state.
This is a huge realization. You can write all the brilliant contracts you want, but if the state won't send someone with a badge and a gun to enforce it against a stranger, it's just a piece of paper.
Exactly. Which leads us to the fourth and final attribute, convertibility. This is the ultimate safety net. It is the attribute that kicks in when the entire system freezes.
Walk me through convertibility. It sounds like turning lead into gold.
It's more like turning paper into state power. Convertibility is the legally enforced ability to transform your private assets into state-backed cash legal tender.
We usually don't think about this during economic blooms because there's always a private buyer willing to buy your financial assets.
But what happens during a massive financial crisis? Markets freeze. Panic sets in. No private buyer wants to touch your complex financial instruments because no one knows what they're worth.
They become completely illiquid.
Yes, private financial instruments can lose 90% of their value overnight.
Yeah.
But state money, the US dollar, the euro, retains its nominal value because it is backed by the state's ultimate power to tax its citizens.
So having the legal privilege to force the conversion of your illiquid assets into cold, hard, state-backed cash on demand.
Or having the state step in as the buyer of last resort. It protects you from market collapses in a way that ordinary citizens simply do not experience.
So we have Priority, durability, universality, and convertibility. Those are the four superpowers. But a lawyer doesn't just wave a wand and grant these powers. They use a specific toolkit.
Right, Pistor's outlines 6 major legal modules that lawyers use to weave these attributes into the fabric of an asset.
Property law, contract law, collateral law, trust law, corporate law, and bankruptcy law.
If we connect this to the bigger picture, we run into a massive glaring paradox in our modern political discourse. If you listen to capitalists, wealthy asset holders, or financial lobbyists, they constantly champion free markets. They demand deregulation.
They argue that state intervention, taxation, and government oversight stifle economic growth. They paint the state as a lumbering beast that only gets in the way of the nimble wealth-creating market.
But based on everything we just discussed, capital cannot exist without the state. That is the core of Pistor's thesis. Capital requires the coercive power of the state.
Without state courts to interpret the contracts, without state bailiffs to execute the judgments, and without state police forces ready to physically enforce your priority and universality rights, your carefully coded capital is meaningless.
The entire capitalist system, the entire edifice of global wealth, is entirely reliant on the state's monopoly over the means of coercion.
This completely upends how we are taught to view the law. We treat the law like it is a neutral referee, just blowing a whistle on a level playing field to make sure everyone plays fair.
But the law isn't the referee. The law is the very cloth from which capital is cut. The state provides the legal tools to the private lawyers, and then the state provides the coercive force to back up whatever those lawyers build.
To truly grasp how deeply entrenched this is, we need to trace how these legal modules were first developed. We need to look at the history of the original capital asset.
Long before anyone was trading complex financial derivatives or patenting software code, wealth meant one thing: land.
Let's ground this in a real-world example of how the law interacts with land and what happens when the state decides not to back your claim. I want to tell you the story of the Belize Maya case from 2007.
It's a very revealing case study.
Imagine the Maya peoples living in the Toledo district of southern Belize. This is their ancestral home. They have lived on, cultivated, and managed this land for centuries, long before European colonizers ever knew the continent existed.
Now, they didn't have a modern land registry. They didn't have stamped, notarized paper deeds in a filing cabinet.
Right. They governed their land through a deeply complex, unwritten set of customary rules, a system of collective use rights known legally as usufruct.
Let's define usufruct because it's a crucial concept. It means they had the legal right to use and derive profit or benefit from property that belongs to another person or a collective, as long as the property is not damaged or destroyed.
They farmed, they hunted, they fished, and they managed the resources sustainably as a tight-knit community. It was a functional, deeply historical system of land management.
But the government of Belize, acting as the modern successor to the British Crown, had a very different view of the law. They claimed that because the Maya didn't have formal, individualized paper legal titles, the kind recognized by English common law, the state essentially owned the land.
And acting on that assumption, the government started granting massive concessions to foreign logging and commercial mining companies. They were essentially selling the right to extract resources right out from under the Maya, tearing up the forests they relied on, without consulting them or offering any compensation.
So faced with the destruction of their livelihood, the Maya fought back. They didn't just protest. They hired lawyers and went to court. They fought this all the way to the Supreme Court of Belize.
And to the surprise of many observers, they actually won.
They did.
How did they win without paper deeds? What was the legal argument?
The court looked at the Belize Constitution, which includes protections against the arbitrary deprivation of property. The court brought in expert anthropologists and historians to testify about the Maya's continuous presence. Ultimately, the Chief Justice ruled that the Maya's century-old unwritten collective use practices actually constituted an interest in real property.
The court essentially bridged the gap between indigenous custom and state law,
Declaring that yes, this collective system is a valid property right, and the government violated it by granting those mining concessions.
It sounds like an incredible underdog victory, a triumph of justice. But this is where the story turns incredibly dark, and where Pistor's X-ray glasses really come into focus. What happened after they won this landmark Supreme Court victory?
The government of Belize simply ignored the ruling of its own Supreme Court.
They just ignored it.
They didn't enforce it. They just kept granting the mining and logging concessions to the foreign corporations. And this perfectly tragically illustrates the brutal reality of the Code of Capital.
Property rights do not exist in nature.
The fact that you have lived somewhere for 500 years means nothing to the machinery of capital unless the state backs it up.
The Maya had the moral high ground, they had the historical claim, they even had the legal victory on paper, but they didn't have the state's coercive power.
Exactly. The state of Belize had a choice to make about whose interests got priority. On one side, you have the sustainable collective practices of an indigenous group. On the other side, you have the promise of immediate commercial revenue from global mining corporations.
The state chose to back the commercial interests. It withheld its coercive enforcement power from the Maya, and by doing so, nullified their capital.
It's devastating. It shows that the state isn't a neutral arbiter. It actively chooses which assets get to wear the armor of capital.
And to see where this playbook was originally written, if we want to look at the blueprint for this kind of legal transformation, we have to travel back to 16th century England and look at the enclosure movement.
If you want to find the birthplace of modern private property rights, the English enclosures are ground zero. Under the old feudal system, land was not owned in the absolute way we think of it today.
It was held in a complex, overlapping web of mutual obligations.
Yes, there were wealthy landlords, but the peasants, the commoners, also had deeply entrenched, legally recognized rights to use the land. They had the right to graze their sheep, to forage for food, and to gather firewood on the commons. The land was a shared resource.
But then the global economy shifted. The wool trade became incredibly lucrative. Suddenly, raising sheep wasn't just about subsistence, it was about massive commercial profit.
Right. And the landlords looked at these sprawling common lands and realized that if they could clear the peasants off and fill the land with sheep, they could make a fortune. So they started literally building physical hedges, digging deep ditches, and erecting fences to enclose the land.
And the commoners didn't just sit back and take it, right? I imagine there was physical resistance.
There was intense physical resistance. The commoners would go out in the middle of the night, tear down the fences, and fill in the ditches. It was a physical battle for survival.
But as Pistor points out, the landlords didn't just rely on physical force.
Physical force is expensive and messy. A much more efficient way to steal the commons was to change the law. So the battle moved from the fields into the courts.
But not the regular courts where the commoners might have a fighting chance based on local custom.
No, the landlords strategically moved the disputes into prerogative courts, like the infamous Star Chamber and the Chancery Courts. These courts relied heavily on written procedures, extensive documentation, and highly educated clerks.
This put the illiterate commoners at an insurmountable disadvantage.
For centuries, the prevailing legal principle governing land disputes was seniority first in time, first in right. The commoners had a solid argument. They said, "We have been grazing our animals here for 10 generations."
So how did the landlords' lawyers defeat first in time, first in right?
By inventing a new legal paradigm. Backed by a rapidly growing, increasingly sophisticated and well-paid legal profession, the landlords argued that their desire to improve the land, meaning to use it for maximum commercial profit, trumped the traditional subsistence use rights of the commoners.
They argued that economic efficiency should be the basis of ownership.
Over decades of relentless litigation, the courts began to side with the landlords. They systematically stripped away the overlapping use rights, birthing the modern legal concept of absolute, exclusive private property.
They fundamentally changed the code. They overwrote the operating system of English land law to prioritize commercial capital over community survival.
And the terrifying thing is that once this legal software was perfected in England, it became an export.
Let's look at how this exact same code was deployed in the United States to justify the legal conquest of Native American land. We have to talk about a Supreme Court case from 1823, Johnson v. Emmentosh.
That case is an absolute masterclass in legal engineering. When European settlers and their descendants expanded across North America, they encountered indigenous peoples who had occupied the land for millennia. Now, if the Old English principle of seniority applied first in time, first in right, the Native Americans unequivocally held superior title to the continent.
But acknowledging that would mean the settlers couldn't legally take the land.
So the lawyers needed a workaround. They needed a new code to justify the taking. And it fell to Chief Justice John Marshall to write it.
Marshall articulated what became known as the Discovery Doctrine. It is a breathtaking piece of legal maneuvering.
Marshall acknowledged that Native Americans were the prior occupants. But he argued that because they did not have a European concept of individual absolute ownership, and because they supposedly didn't improve the land in a commercial capitalist sense, they did not possess true property rights. They only possessed a mere right of occupancy.
A right of occupancy, like they were just crashing on a couch.
Exactly. And Marshall wrote that the act of discovery by European Christian nations granted those colonizing nations an exclusive overriding right to extinguish the Indian title of occupancy, either by purchase or by conquest.
By simply changing the legal code, by legally declaring that European discovery and capitalist improvement magically trumped centuries of physical occupancy, the United States legally transformed Native Americans into mere squatters on their own ancestral lands.
It was conquest by legal definition. The military fought the physical battles, but the lawyers fought the structural battles. The legal software was rewritten to ensure that the ultimate asset, the North American continent, was transferred to those who intended to use it for capitalist wealth accumulation.
So now the landlords in England and the settlers in America have their absolute property rights. They have priority. They own the land exclusively. But as we discussed earlier, priority is only the first step. Absolute ownership comes with a massive vulnerability.
Right, because if I own my massive estate absolutely, and I decide to take out a massive loan to fund a new business venture, or maybe I just have a terrible gambling addiction and I default on my debt, my creditors can come after my assets.
They can seize the family estate. Absolute ownership means absolute exposure to creditors.
Precisely. And the landed elites realized they were in danger of losing their newly enclosed wealth to their own poor financial decisions. This is where the lawyers had to invent something entirely new to create that second attribute, durability.
To understand the terrifying danger of debt without durability, Pistor uses a brilliant literary analogy. She points to Shakespeare's play, The Merchant of Venice.
Let's walk through this because it perfectly illustrates the ruthless logic of contract law. You have the merchant, Antonio. He wants to help his friend Bassanio, who needs money to court a wealthy heiress. Antonio is rich, but all his wealth is tied up in merchant ships currently out at sea. He is asset-rich but cash-poor.
So he goes to the moneylender, Shylock, for a loan.
And Shylock agrees, but he demands a very specific, gruesome form of collateral. The contract states that if Antonio defaults on the loan, Shylock is entitled to exact a pound of Antonio's flesh from nearest his heart.
It's the ultimate collateral. And then, of course, disaster strikes. Word arrives that Antonio's ships have capsized. His wealth is gone. He's illiquid. He defaults on the loan. Shylock shows up in court, knife in hand, demanding his pound of flesh.
He is demanding his absolute legal priority right to the collateral.
And the fascinating part of the play is the reaction of the state. The Duke of Venice is presiding over the court. The Duke pities Antonio, but he refuses to intervene and void the contract.
Why? Because Venice is a commercial hub. If the state arbitrarily cancels a valid contract, foreign merchants will lose faith in the Venetian legal code and capital will flee. The strict enforcement of the legal code must be respected, even if it costs a man his life.
So Antonio is doomed by the inflexibility of the law. But then a lawyer steps in to save the day. Portia arrives in the courtroom, disguised as a legal expert.
And pay attention to Portia's strategy. She doesn't argue that the contract is immoral or invalid. She doesn't ask for mercy. Instead, she uses an incredibly narrow, hyper-literal interpretation of the code. She tells Shylock, the law is on your side. You may have your pound of flesh.
But look closely at the contract.
It mentions flesh, but it mentions no blood. If in cutting the flesh, you spill a single drop of Christian blood, the laws of Venice dictate that all your lands and goods will be confiscated by the state.
She finds a loophole. She uses the strictness of the law against itself to shield the asset, in this case, Antonio's life. And Pistor uses this analogy to explain that this is exactly what English lawyers did for the landed elites.
They couldn't change the fact that creditors had a right to collect debts, so they found a loophole. They invented incredibly ingenious legal modules to shield the land from the creditors. They invented things like the use, the trust, and the strict family settlement, which is also known as the entail.
Let's focus on the trust, because it is a uniquely Anglo-American legal invention, and it remains one of the most powerful tools of wealth preservation in the world today. It is a masterpiece of asset shielding. Let's walk through the mechanics of how a trust actually works.
Okay, let's say I am a wealthy 18th century English lord. I own a massive estate. I have a son who I know is a degenerate gambler, and I am terrified that when I die, he will inherit the estate, rack up debts, and the creditors will seize the ancestral home.
How does a trust fix this?
It fixes it by shattering the concept of absolute ownership into pieces. You, the wealthy lord, are the settler. You take the formal legal title of your estate and you transfer it to a third party, the trustee. This could be a trusted lawyer or a bank.
The trustee officially manages the land.
But the trust document stipulates that all the economic benefits of the land, the farming revenue, the rents, must go to a beneficiary. In this case, your son.
So I don't own it anymore. The trustee owns it, but my son gets the money. How does this stop the creditors?
It creates an impenetrable legal fortress. If you, the original lord, suddenly go bankrupt before you die, your personal creditors cannot touch the land because you legally gave it away. You don't own it.
What if the trustee goes bankrupt?
The trustee's creditors cannot touch the land because the trustee only holds it in trust. It's not part of their personal wealth.
And what about my gambling son? When his bookies come looking for their money, what happens?
The bookies are blocked. The son only has a right to receive the income stream. He does not hold the legal title to the underlying property. He can't sell the estate to pay his debts, and his creditors can't force the sale of an asset he doesn't officially own.
The trust perfectly insulates the core capital from the disastrous financial decisions of the humans involved. It grants the land incredible multi-generational durability.
It is brilliantly conceived, but in a very dark, system-rigging kind of way. It ensures that the rich stay rich regardless of their competence. And this was incredibly popular. By the mid-19th century, something like half to two-thirds of all the land in England was locked up in these entails and trusts.
But eventually, locking up all the land became an economic bottleneck. As the Industrial Revolution took off, capitalists didn't just want ancestral estates. They needed massive amounts of liquid capital to build factories and railroads. And so the legal code had to evolve again.
Exactly. The code had to pivot from just protecting land to accelerating commerce. If the blueprint was drawn in the 16th century with dirt, how did it evolve when we started dealing with massive industrial enterprises? This brings us to a revolutionary leap in legal engineering, the creation of the modern business corporation. We move from coding land to literally cloning legal persons.
Here's where it gets really interesting. I want to spend a lot of time on the corporation because I think most people fundamentally misunderstand what it is. If you ask the average person on the street what a corporation is, they'll say it's a business. It's a group of people working together in an office building to sell a product.
Economists often describe it as a nexus of contracts between managers, employees, and suppliers.
But Pistor argues that view completely misses the magic trick. A corporation isn't just a way to organize people. It is a legal container. It is a capital mint. It is designed to aggressively separate ownership from liability.
To understand the power of this legal container,
Yeah.
we need to break down the three specific superpowers that corporate law grants to an asset pool. The first superpower is entity shielding.
Let's walk through entity shielding with a hypothetical. Say I have $50,000 and I decide to buy shares in a massive global coffee chain. What does entity shielding do for the coffee chain?
Entity shielding protects the assets of the corporation from the personal creditors of the shareholders. Let's say you take that $50,000, buy the coffee stock, but then in your personal life you make a terrible financial mistake. You are sued, you lose, and you personally declare bankruptcy. Your creditors are going to scour your life looking for assets to seize.
They will take my house, my car, and they will take my shares in the coffee company.
Yes, they will seize your shares. And this is the crucial boundary of entity currents. Shielding your personal creditors cannot reach inside the coffee corporation itself. They cannot force the coffee chain to sell one of its espresso machines or drain its corporate bank account to pay off your personal debts.
The corporation's assets are shielded from you and your mistakes.
This legal wall gives the business the absolute stability to operate and plan for the future without constantly worrying about the shifting personal financial health of its thousands of investors.
That makes perfect logical sense. A business couldn't function if it had to liquidate equipment every time an investor got a divorce. But the second superpower is the one that turns this concept on its head. It's the one everyone has heard of, and it is the source of endless controversy. Loss shifting, more commonly known as limited liability.
If entity shielding protects the corporation from the owners, limited liability is the ultimate owner shield. It protects the owners from the corporation. It dictates a remarkably asymmetrical rule. Shareholders can reap unlimited upside profits if the company succeeds, but if the company completely fails, The shareholders only lose their initial investment, the price they paid for their shares. They are strictly legally insulated from the corporation's debts.
Let me make sure I am grasping the scale of this. Let's say I own shares in a chemical company. The executives at the company decide to cut corners on safety. A factory explodes, causing a massive environmental disaster, billions of dollars in cleanup costs, and catastrophic health issues for the local town. The company is sued into oblivion and owes $10 billion more than it has in the bank.
Under limited liability, the victims of that disaster can liquidate the chemical company's assets, but once the company's empty, they must stop. They cannot come after you, the shareholder, to make up the difference. Your personal bank account, your home, your other investments, they're completely untouchable, even though you are technically the part owner of the enterprise that caused the destruction.
You lose the value of your shares, but you walk away from the multi-billion-dollar fallout. So who eats the loss? The victims just don't get paid.
Exactly. The losses are legally shifted away from the owners and pushed onto the company's creditors, onto tort victims like the people in the town, or very often in the case of financial firms, onto the state and the taxpayers in the form of massive government bailouts.
Limited liability is a legally sanctioned mechanism for privatizing all the gains and socializing all the catastrophic losses. It encourages massive risk-taking because the downside is legally capped.
And then there's the third superpower, which makes corporations feel almost mythological: immortality.
Immortality.
Unlike a human being whose wealth must pass through the vulnerable transition of death and inheritance, or a simple partnership which legally dissolves the moment a partner dies or leaves, a corporation is recognized by the state as a separate, immortal, legal person. It survives the death of its founders.
It can theoretically live forever, incubating wealth, compounding returns, and executing strategies across centuries, terminating only if it is legally liquidated by a court or its board.
I found it incredibly fascinating that Pistor traces the historical precedents for this corporate structure. We think of the multinational corporation as this hyper-modern 20th century capitalist invention. But the psychological desire to separate profits from liability goes back much further.
The Romans actually used a very similar conceptual loophole, didn't they?
Yes, the Romans were brilliant legal engineers in their own right. They had a concept called the peculium. This was essentially a slave-run business.
Correct.
Under Roman law, the slave was property, but they could be granted a peculium, a specific bundle of assets, like a sum of money or a shop to manage on behalf of their master.
Two wealthy Roman patricians could set up a trading business, place it under the management of a highly educated slave they jointly owned, and allocate a specific peculium to it.
Why not just run the business themselves? Why use the slave as a proxy?
Because it created a primitive form of asset partitioning. If the trading business failed and racked up debts, the Roman law generally limited the master's liability strictly to the value of the peculium. The creditors could take the shop, but they couldn't reach into the patricians' sprawling country estates or personal treasuries.
Their personal wealth was legally walled off from the business's creditors.
It's the exact same impulse as limited liability. And Pistor also connects this desire to partition assets to the Renaissance, specifically to the Medici family in 15th century Florence. They built this unprecedented, sprawling banking and trading empire that financed popes and kings across Europe.
But the genius wasn't just in their accounting. It was in their legal structure. They didn't incorporate as one giant Medici Inc., did they?
No, because modern corporate law didn't exist yet. Instead, the Medici relied on a highly sophisticated, incredibly complex network of bilateral partnerships, what they called a sistema di aziende. The senior Medici partners in Florence didn't own a monolithic company. Instead, they set up separate, distinct legal partnerships for every single line of business and every geographic location.
So they had a separate partnership for the London Bank, a separate one for the Bruges branch, a separate one for the Sylph trade, and a separate one for alum mining.
Precisely. And this modular structure was a masterpiece of entity shielding. Let's say the King of England defaults on his massive loans, and the London branch goes completely bankrupt. The furious creditors in London could seize the assets of the London partnership.
But because the London branch was a legally distinct partnership from the Florence branch, the English creditors couldn't legally cross the continent and seize the massive gold reserves held by the Florence branch.
Nor could they easily reach the personal wealth of the senior Medici partners. It localized the risk to a single city while allowing the profits from all the cities to flow centrally back to the family.
Exactly. And by legally partitioning their assets this way, the Medicis spurred a massive credit boom. Local creditors in Bruges or London felt very secure lending to their specific local branch, looking at the assets sitting in their city, often not realizing how completely opaque and over-leveraged the total European-wide debt structure of the Medici family actually was.
Which brings us perfectly and tragically to the modern equivalent of the Medici Empire. We are going to look at one of the most infamous case studies in financial history, the collapse of Lehman Brothers in 2008.
The story of Lehman is the ultimate demonstration of what happens when the legal code of the corporation is pushed to its absolute breaking point.
To understand the catastrophe of Lehman Brothers, you have to understand its history, because it perfectly illustrates the psychological difference between a partnership and a corporation. Lehman was founded in 1850. For over 130 years, it operated as a traditional partnership.
Meaning the partners who ran the bank were personally liable for its debts.
Completely liable. If the bank failed, the partners lost their houses, their savings, everything. Because their own skin was fully in the game, the culture of the firm was inherently cautious. They scrutinized every risk.
And because of that structural prudence, Lehman Brothers survived the American Civil War, 2 World Wars, the Great Depression, and massive seismic shifts in the global monetary system. They endured for 130 years.
But then the legal structure changed. In 1983, Lehman Brothers Incorporated. They abandoned the partnership model and became a corporation with limited liability.
And just 14 years later, operating under the intoxicating protection of the corporate shield, their risk-taking behavior was completely unleashed. Without personal liability holding them back, they leveraged the firm to extraordinary levels, bought up incredibly toxic assets, and triggered the largest bankruptcy in human history, bringing the entire global financial system to the brink of total collapse.
Let's look at the actual legal web of Lehman Brothers, because just like the Medici, it wasn't just one simple company. It was an incredibly complex, intentional labyrinth of legal entities.
Lehman utilized asset partitioning on a scale that would make the Medici look like amateurs. They didn't just have a few branches, they had hundreds upon hundreds of separate legal subsidiaries scattered across the globe. They had dozens incorporated in Delaware to take advantage of corporate-friendly laws. They had massive operations in London. They had over 30 entities registered in the Cayman Islands specifically for regulatory and tax arbitrage.
So you have this massive spider web of subsidiaries. But sitting at the center of the web is the parent company, Lehman Brothers Holdings, Inc., or LBHI. What did LBHI actually own?
Very little physical substance. LBHI held almost no tangible assets itself. Its balance sheet was primarily made up of the paper shares it owned in its hundreds of subsidiaries.
But here's the trick, the fatal flaw in the legal engineering. To fund this massive global operation, all those little subsidiaries needed to borrow billions of dollars. But creditors didn't want to lend to a tiny Cayman Islands subsidiary with no track record. They wanted the backing of the big parent company. So what did LBHI do?
LBHI guaranteed the debt of the subsidiaries. To secure cheap, abundant debt financing, the parent company contractually agreed to backstop the losses of its offspring. In doing so, LBHI effectively traded away its limited liability at the corporate level.
But, and this is the punchline of the whole system, what about the human beings who own the shares of LBI, the executives and the investors?
The human shareholders of LBHI fully retained their personal limited liability. They pocketed the massive dividends and bonuses generated by this highly leveraged, incredibly risky interlocked structure during the boom years. And they did so knowing with absolute legal certainty that they would never personally be on the hook if the whole house of cards collapsed.
And when it did collapse in September 2008, those legal shields, which were designed to protect wealth, turned into an absolute nightmare for the creditors trying to clean up the mess. Pistor details a specific mind-boggling dispute known as Rascals that perfectly captures the chaos. Can you explain the Rascals dispute?
RASCAL stands for Reliance on Affiliate Subcustodian Account Ledger System. It was a highly automated internal accounting system that Lehman used to optimize its regulatory capital requirements. Every single day, the system would sweep billions of dollars of securities back and forth between its London branch, LBIE, and its Swiss branch, LBF.
Wait, I want to make sure I understand this. They were literally passing massive piles of assets back and forth across international borders every single day, just to make their balance sheets look better to regulators.
Yes, depending on the time of day, the assets would sit in London to satisfy UK regulators and then move to Switzerland. But when the music stopped and Lehman suddenly filed for bankruptcy in New York, the automated Rascal system froze.
So where were the assets when the music stopped?
That became a multi-billion-dollar legal question. The London branch administrators claimed they owned the assets because they were physically located there when the freeze happened. The Swiss branch administrators pointed to contracts claiming the London branch was merely holding them in trust and the assets legally belonged to Switzerland.
It's astounding. They used the legal code to maximize profits and evade regulations, but when the firm blew up, that same fragmented legal code made it impossible to sort out the wreckage. It took a multi-year, multi-million-dollar legal battle just to figure out who legally owned what, because the assets were trapped between different sovereign legal jurisdictions and corporate shields.
And this brings us to a crucial pivot in our discussion. Because it wasn't just complex corporate structures that caused the 2008 crisis, it was the way lawyers had learned to code debt itself into capital. If we want to understand the true engine of the crash, we have to examine the securitization of debt, specifically residential mortgage-backed securities, or RMBS.
Okay, let's walk through this process step by step, because this is where the alchemy of law really gets wild. To understand securitization, you have to realize how boring a mortgage used to be. For most of history, if I wanted to buy a house in Ohio, I went to my local bank, I signed a contract, the bank gave me the money, and they had that mortgage on their books for 30 years. I mailed them a check every month. It was a personal, highly illiquid contract tied to a specific piece of dirt and my specific ability to pay.
But Wall Street financial engineers realized that holding on to a 30-year loan was an inefficient use of capital. They wanted to turn those slow, local loans into fast, global capital. They realized that if they could pool thousands of these illiquid mortgages together and legally recode them, they could sell the income stream to global investors.
Pistor walks us through a very specific real-world example of this. The NC2 Trust, which was created by Citigroup and New Century Financial. How did a lawyer take my local Ohio mortgage and turn it into a global financial asset?
They used our old friend from the English-landed gentry. The trust. Citigroup bought thousands of mortgages from originators like New Century. They took all these thousands of pieces of paper and placed them into a newly created legal shell, the NC2 Trust. By putting the mortgages inside the trust, the lawyers achieved a highly coveted legal status known as being bankruptcy remote.
Bankruptcy remote. I need you to explain that in painful detail. What does bankruptcy remote actually mean for an investor in Germany who wants to buy a piece of this trust?
It means that the assets inside the trust, the thousands of mortgages, are completely legally insulated from the financial health of the bank that created the trust. Let's say Citigroup goes completely bankrupt. Normally, Citigroup's creditors would seize all of its assets to pay its debts. But because the mortgages were transferred into the NC2 Trust, Citigroup's creditors cannot touch them. The trust is a standalone, impregnable legal fortress. The German investor knows that even if Wall Street collapses, the income stream from the Ohio homeowners flowing into the trust is legally safe.
So the trust creates the durability. But how do they make it appealing to different types of investors?
Once the mortgages were secured in the trust, the lawyers used contract law to slice up the income stream from those mortgages into different tranches, or tiers of risk and return. The top tranches were legally coded to get paid first. They had priority. Because of this priority, rating agencies slapped a AAA rating on them, making them seem as safe as government bonds. The bottom tranches took the first losses if homeowners defaulted, but they offered much higher yield to attract risk-seeking investors.
So they took a massive pile of ordinary, often incredibly risky subprime home loans, ran them through the legal modules of trust and contract law, and minted trillions of dollars of new, tradable, supposedly safe financial assets. But as we all know, the underlying assets, the houses in Ohio and Nevada, and the borrowers who couldn't afford them were incredibly fragile. When the housing bubble burst, the homeowners defaulted en masse. And suddenly, these complex derivatives lost all their market value.
And this is where the ultimate, most exorbitant privilege of capital comes into play. Convertibility and priority in the face of total systemic failure. When the 2008 crisis hit, the financial elites holding these derivatives didn't just shrug and accept the brutal logic of the free market. They didn't accept their losses. They relied on special legal carve-outs that they had spent decades quietly lobbying for.
You are talking about the safe harbors in bankruptcy law. When I read this section of Pistor's book, my jaw literally dropped. This is the smoking gun of legally structured inequality. Walk us through what a safe harbor is.
It is truly staggering when you understand the mechanics of it. Ordinarily, when a corporation files for bankruptcy, the court imposes an automatic stay. This is a fundamental rule of bankruptcy law. It means a freeze is put on all the company's assets. All the creditors have to stop collecting, put their weapons down, and wait in line while a bankruptcy judge carefully sorts out who gets what based on the established rules of priority.
It's meant to prevent a chaotic run on the bank, where the first person in the door takes everything and everyone else gets nothing.
Exactly. But over the decades preceding the 2008 crisis, the financial industry successfully lobbied legislatures in over 50 countries, including the U.S. Congress, to create explicit safe harbors, specifically for derivative contracts and repo transactions.
So they changed the bankruptcy law just for themselves.
Yes, they literally coded an exception into the law. The law explicitly exempted these complex financial instruments from the automatic stay. So, when Lehman Brothers failed, the counterparties holding derivatives were legally allowed to bypass the bankruptcy court completely. They did not have to wait in line. They were legally permitted to immediately terminate their contracts, seize the collateral Lehman had posted, and run.
They gotta jump the line. They raided the vault before the judge even opened the courtroom doors.
They raided the vault, leaving the ordinary unsecured creditors, the employees who lost their pensions, the small businesses that provided services, the local municipalities staring at an empty shell. It was a legally sanctioned, hyper-accelerated bank run, coded into the law long before the crisis ever hit. It ensured that the absolute most sophisticated, wealthiest actors got out first, while everyone else absorbed the losses.
It is legally structured inequality at the absolute highest level. And what's wild to me is that these financial instruments, these derivatives, are traded globally. They cross borders instantly. But there is no global government. There is no global police force, no global bankruptcy judge. So if capital requires state coercion, how does this global empire of law actually function without a global state?
It functions through a relatively obscure but incredibly powerful area of law called conflict of law rules. As capital became increasingly global in the late 20th century, corporate lawyers realized they didn't need to build a single unified global legal system. That would be politically impossible. Instead, they just needed sovereign states to agree to respect and enforce the laws of other states.
How does that work in practice?
Conflict of law rules allow private parties entering into a contract to explicitly choose which country's legal system will govern their transaction, regardless of where they are physically located.
So if a massive bank in Germany is doing a complex derivative deal with an institutional investor in Japan, they don't have to use German law or Japanese law. They can just write into the contract that the deal is governed by, say, English law.
Exactly. And the crucial part is that the domestic courts in Germany and Japan have legally agreed to recognize and enforce that choice. If a dispute arises, the German judge will apply English law to settle it. Because of this remarkable dynamic, global finance essentially runs on just two legal systems, English common law and the state law of New York. The jurisdictions of London and New York City dominate the global economy because they offer the most flexible, capital-friendly legal environments, and sovereign states around the world have universally agreed to enforce their rules.
But this raises a terrifying constitutional question. What happens when global capital comes into direct conflict with the sovereignty of a democratic state? What happens when a country's elected government wants to pass laws to protect its citizens, maybe environmental regulations or public health laws, but those laws threaten the expected profits of global capital?
This brings us to a mechanism known as Investor-State Dispute Settlement, or ISDS. This is a provision that lawyers began embedding into thousands of bilateral investment treaties and international trade agreements, like the former NAFTA. ISDS allows foreign corporate investors to directly sue sovereign states in private international arbitration tribunals if the state passes laws or regulations that negatively impact the investor's expected profits.
Wait, a private corporation can sue a sovereign country because the country changed its own laws? Give me an example of this because it sounds like science fiction.
Here's a chilling example. The American pharmaceutical giant Eli Lilly taking on the sovereign government of Canada.
Walk me through what happened.
Canadian courts, applying Canadian domestic patent law, had invalidated two of Eli Lilly's drug patents. The Canadian judges argued that the drugs didn't meet the legal requirement of delivering the specific benefits they had promised when the patents were filed. Now, normally, a Supreme Court ruling is the final word in a sovereign nation. But Eli Lilly didn't just accept the ruling of Canada's highest court. Instead, they used the ISDS provisions under NAFTA to sue the Canadian government for $500 million in damages.
What was their legal argument? How can a company sue a country just because the country's own Supreme Court interpreted its own patent law?
They argue that the Canadian court decisions violated NAFTA's open-ended commitments to provide fair and equitable treatment and protection against indirect expropriation. Eli Lilly essentially argued that their expectation of future monopoly profits constituted a property right under international law, and that Canada's domestic court ruling expropriated that property.
So they were trying to elevate a private trade agreement above the constitutional sovereignty of a democratic nation's judiciary.
Precisely. Now, ultimately, Eli Lilly lost that specific arbitration. But the fact that the case was heard at all, the fact that a private tribunal composed of 3 corporate arbitrators spent 2 years reviewing and judging the rulings of a sovereign nation's highest court proves the incredible overriding power of the global legal code. It proved that capital has the tools to challenge, delay, and chill democratic lawmaking if it threatens their coded wealth.
Okay, we have talked extensively about the code itself. We have talked about the assets. But to truly understand this system, we need to talk about the coders. If capital is a legal construct, who is doing the constructing?
The true masters of capital are not the tech entrepreneurs. They are not the hedge fund managers, and they are certainly not the CEOs. The masters of the code are the elite private lawyers working in the world's top corporate law firms in New York and London. Economists usually dismiss lawyers as mere transaction cost engineers, people who just smooth over the friction of business deals and draft the paperwork. But Pistor argues they are the actual architects of wealth. They take the raw materials of the law and fashion entirely new capital assets.
And it is no coincidence that the centers of global finance, New York and London, are both governed by common law systems. Why does the common law give these elite lawyers such a massive advantage compared to civil law systems like you find in France or Germany?
It comes down to how the law evolves. In a civilized system, which derives from ancient Roman law, the law is highly codified by the state. It is written down in comprehensive statutes. The state closely guards the creation of new legal rights. If a lawyer wants to invent a new financial instrument, they often have to wait for the legislature to pass a new law explicitly allowing it.
But the English common law system is different.
Very different. The common law evolves organically through judicial precedent. Private lawyers are constantly pushing the boundaries, fashioning new legal rights from old cloth in their private offices. They construct a new derivative or a new corporate structure, and they just start using it. And when those new structures eventually face a legal challenge, who is sitting on the bench making the ruling? A judge who was, until very recently, a highly paid private corporate lawyer themselves. The common law system is inherently, structurally sympathetic to private legal innovation.
And this dynamic gives these elite lawyers what Pistor calls a massive first-mover advantage.
Absolutely. The legal system is incredibly asymmetrical in favor of the coders. Elite lawyers are constantly pushing the boundaries of what the code allows. Look at the realm of intellectual property. A few decades ago, lawyers successfully argued that you could patent genetically modified organisms. Then they pushed further and argued you could patent isolated segments of human DNA. Or look at corporate defense tactics like the famous poison pill.
Right, the poison pill. This is a great example. It was invented by a single corporate lawyer, Martin Lipton, to prevent hostile takeovers of corporations. It essentially floods the market with new shares. If an unwanted buyer tries to take control, massively diluting the buyer's stake and making the takeover financially ruinous.
Exactly. Lipton invented this highly aggressive legal structure in his office and deployed it for his clients. Now, was it legally valid? Nobody knew for sure. Because the legal system relies on private parties to police infractions, meaning someone has to have the money, the time, and the legal standing to sue it. It can take years, sometimes decades, for a court to finally review whether this new legal invention actually holds water.
And during that lag time, the wealthy clients are using the invention. By the time a Supreme Court finally issues a ruling, the asset holders have already extracted massive wealth. The damage is done, the profits are banked. It's a game where acting first and asking for legal forgiveness later is massively profitable. So bringing this back to you, the listener, think about the political debates that dominate our news cycles. When you hear debates raging about wealth inequality, about whether to tax the rich, about regulating Wall Street, or closing tax loopholes, look past the politicians. Look at the lawyers. They're the ones paid thousands of dollars an hour to construct these invisible legal fortresses. They place assets completely beyond the reach of tax authorities and ordinary creditors. The inequality we see around us is not a glitch in the free market. It is a legally structured outcome, meticulously designed by the masters of the code.
Which brings us to our conclusion, summarizing this deep dive into the crisis in perception. The crisis is the prevailing belief that wealth inequality is a purely market-driven outcome. We have been taught to see capital as an economic phenomenon, But once you see the legal architecture, you realize that capital is engineered privilege.
It's a completely different paradigm.
It is. Understanding that capital is coded in law reconnects law, finance, politics, and wealth distribution into one single structural system. You can no longer separate the economy from the state because the state's coercive power is the only thing that enforces the priority, durability, universality, and convertibility of capital.
So the million-dollar question, how do we fix it? If the system is legally rigged by design, how do we unrig it?
Pistor offers several pragmatic solutions. First, we must aggressively roll back the exorbitant legal privileges that have been handed to capital. We have to stop treating speculative financial derivatives better than ordinary debt and bankruptcy court. We need to eliminate the safe harbors that allow financial elites to jump the line. Furthermore, we must force capital to be subject to the laws of the countries where it actually operates and extracts wealth, rather than allowing corporations to indefinitely jurisdiction shop for the most lenient rules. We must democratize the code by ensuring that the law serves the public interest, not just the private wealth accumulation of the few.
I want to leave you with a final provocative thought. We have spent this deep dive exploring how law is the code of capital. But what happens when a new technology tries to replace that law with digital code? Look at the rise of cryptocurrencies, blockchain technology, and DAO's decentralized autonomous organizations. The evangelists of Web3 promise a utopian vision where we bypass the legal state entirely. They claim that smart contracts and cryptographic code will perfectly enforce property rights and agreements, eliminating the need for lawyers, courts, and state coercion.
It is a fascinating proposition, but it raises a critical question based on everything we've discussed. The legal code, for all its flaws, complexities, and structural biases, is ultimately tethered to a state that has some measure of democratic accountability, however imperfect. If you completely remove the state and rely purely on digital code, who will protect you when the code inevitably fails, or is hacked, or operates in ways you didn't anticipate?
Exactly. Does replacing the legal code with digital code actually democratize wealth? Or does it just create a new, even less accountable class of master coders, software engineers, instead of corporate lawyers who can extract wealth without any oversight from society whatsoever? It is something to keep a close eye on as the definition of capital continues to evolve. Crisis in Perception examines how systems shape belief and how better tools help us see clearly. This project is free and publicly accessible. If you'd like to support the time, tools, and research behind Crisis in Perception, you can become a supporter on Patreon. For a shorter visual overview of this topic, see the mini explainer linked in the description. If you enjoy this kind of systems-level analysis, please like, subscribe, and comment with books or topics you'd like us to explore next.